हेलो फ्रेंड्स, कैसे हैं? होपफुली सारे अच्छे होंगे। तो यहाँ पे एक इम्पॉर्टेंट अपडेट है, दैट इज़ बाय द रिटायरीज एसोसिएशन। तो यहाँ पे अभी शेयर करेंगे उनका जो रेफरेंस लिया है उन्होंने। तो यहाँ पे इन द केस ऑफ डी एस नकारा वर्सेस यूनियन ऑफ इंडिया, माय अपॉलॉजीज। तो यहाँ पे आई थिंक यहाँ पे डी एस नकारा वर्सेस यूनियन ऑफ इंडिया का जो केस है बाय द हॉनरेबल सुप्रीम कोर्ट ऑफ इंडिया एंड रिगार्डिंग नॉन पेमेंट ऑफ द पेंशन। तो यहाँ पे एक छोटा सा अपडेट है इन अ वेरी क्विक मैनर, वी कैन सी दैट एग्जैक्ट अपडेट। सो यहाँ पे दोस्तों, यहाँ पे चैनल को सब्सक्राइब कर लेना अगर आप अभी तक चैनल के साथ नहीं बने हैं। तो चैनल को सपोर्ट कीजिए और वीडियो को दोस्तों लाइक कर देना। इट्स अ रिक्वेस्ट फ्रॉम बॉटम ऑफ माय हार्ट। सो यहाँ पे स्टार्ट करते हैं विद द एग्जैक्ट अपडेट। क्या अपडेट रही है दोस्तों, और इस वीडियो को बनाने का मकसद क्या है? बड़ा छोटा सा मैसेज है इस वीडियो में, तो दैट आई एम गोना शेयर अमंग ऑल ऑफ यू। तो यहाँ पे आप देख सकते हैं द मैसेज इज बीइंग बाय द स्टेट बैंक रिटायरीज एसोसिएशन। ये रिटायरीज एसोसिएशन की तरफ से है, बट इट इज़ एप्लीकेबल फॉर ऑल द रिटायरीज। ऑलमोस्ट सारे बैंक्स के रिटायरीज के लिए ये एप्लीकेबल है फ्रेंड्स। सो यहाँ पे रिस्पेक्टेड आर नॉन पेमेंट ऑफ पेंशन ऑन अकाउंट ऑफ alleged नॉन सबमिशन ऑफ LC। सो इसमें एक्चुअल में है क्या? Respected sir, the principle of natural justice is basic doctrine of law. Before depriving any benefit or privilege, it is incumbent upon the party depriving the benefits or privilege to inform and seek his view, reply, opinion. अगर इसमें कोई भी deprivation होता है without following the principle of natural justice is illegal and bad in the eyes of law. तो यहाँ पे वी गोना सी, हम क्विकली आते हैं टॉपिक के ऊपर। So, in case the bank sends a notice to the correct address with a view to follow the principle of natural justice, if it is not returned and delivered, the said notice is deemed to have been delivered to the addressee, that is the pensioner, in terms of Section 27 of the General Clause Act 1897, unless contrary is approved. If the notice is delivered or served the addressee of the letter, the pension is deemed to be alive. So then the bank cannot stop payment of pension, presuming that the pensioner is not alive. So the bank is duty bound to pay pension from the day following his or her retirement, and family pension from the day following demise of his spouse, parent, as the case may be. So the bank cannot deprive payment of pension, at least to the extent of minimum pension, even in case of those who are convicted of serious offense or on account of major misconduct at any point of time till he or she survives. So therefore, unless the bank has knowledge of that, the pension cannot be stopped unilaterally. So in terms of Section 107 of Evidence Act 1972, when the question is whether a man is alive or dead, and it is shown that he was alive within 30 years, the burden of proving that he is dead is on the person who affirms it. So therefore, the onus of proving death of pensioner lies with the bank. So if payment of pension is stopped by the bank, as the pensioner are entitled to receive pension as long as they are alive. So we wish to bring you kind notice that Honorable Supreme Court has decided that the pension is property in the Katina of judgment, including judgment in Deukandan Prasad versus State of Bihar, replying on the decision of Honorable Supreme Court in DS Nakara versus Union of India 1983. Uh, Honorable Supreme Court in the State of Jharkhand versus Jitendra Kumar Srivastava has decided as under. The fact remains that there is a imprimatur to the legal principle that the right to receive the pension is recognized as a right in property. So Article 300A of the Constitution of India reads that under 300A, person has not to be deprived of property save by the authority of law, and no person shall be deprived of his property save by authority of law. तो यहाँ पे this is the main clause here. It is being compared with the right to property. So once we proceed on the premise, the answer to the question posed by us in the beginning of the judgment becomes too obvious. A person cannot be deprived of pension without the authority of law, which is constitutional mandate under Article 300A of Constitution. So it follows that attempt to appellant to take a part of pension or gratuity or even have in case encashment without any statutory provisions any and under the umbrage of administration instructions cannot be contranast. So rest of the you can study very easily. So this was very important, so I thought to share among all of you. So दोस्तों यहाँ पे please make sure to subscribe to channel and please like the video if you like the content here.